Brian mentioned his book, and I've been trying to do my part, and because I actually am a verified purchaser and have read it, but I'm going under the pseudonym, very politically incorrect, William Lowndes Yancey. And a woman, I think it was a man, commented on his book, very interesting hypothesis that the Constitution of the United States was written as a static document and that any change in the branches of government should adhere to this document as written and approved by the founding generation, a hypothesis. So, I just had to be kind of sarcastic when I replied to that. So it was, I'm going to get it exactly right. I said, because I think there was a little more going on, and then meets eye with this, I said, there has been a debate going for over 100 years between proponents of originalism and pragmatism, or the living Constitution. If you were not aware of this, what Combe Award have you been in? ? It's bad enough that you didn't read the book, but not knowing basic constitutional arguments, well, George Soros didn't get his money out of you. And just left it at that. That was strange. I'm not selling these, but I found this a few weeks ago. $1.99, and this is the first phone app I've ever downloaded, and it was kind of hard to do because I don't download phone apps, but there's one called U.S. Historic Documents. It's made by, I think it's Workman's Technology, like Workman's Comp, LLC. It has got everything from the Stamp Act to the Articles of Confederation to the Treaty of Ghent. I mean, you can't believe it. And it's all in a nice little package on your phone. It's called let me make sure it's historical. Let's see. Get the exact name of it. U.S. Historical Documents. And either Android or iPhone, they sell them both. The first state constitutions, not them now. Stamp Act, Albany Plan. I mean, it's amazing.
Historic or
historical? Historical. Now, they sell another one. That's what I was into. It's called CCW. It's great if you carry a gun. It has the laws of all of the states, so you can click it, and it'll take you to the state code, and it's $1.99 too. I mean, how does somebody make money doing that? I don't know. But apparently they do. I was telling Brian I was arrived late a little last night, and maybe y'all can help me. I have been on a quest for 30, 40 years trying to find a stop sign or a yield sign somewhere south of the Mason-Dixon line that doesn't have a bullet hole or a buckshot hole in it. And I thought there was one near Noonan around Palmetto. We got off, buckshot hole in it, number $3. But if you ever see that, get to me quick, because it's not going to last long. I think it's 72 hours between getting put up and getting shot. In fact, I've had an urge to actually shoot one. I mean, there's just something about a pristine traffic sign like that. It's funny you mentioned University of Alabama. I debated, we don't have any con law teachers in here, do we? Because the minute I say that, there's one in here. They're the most arrogant know-it-alls, you'll ever come in contact with. So I debated one there at Jones Law School in Montgomery, and he was in the, Obama administration, maybe Clinton's, who knows. But he teaches here, is it Georgia State, University of Georgia, whatever the law school is in Atlanta, or I think it's Neil Kinkoff. And he's actually a pretty nice guy, but of course, I had my briefing book like this. It was on a gun, right after all the gun, the shootings on Sandy Hook. And so he gets there, and of course, I had the audience kind of stacked with a lot of people from the court system. Anybody wants to know about Roy Moore's case, I'm up on it. So I start off, and and then his response was, I wasn't really sure this was a debate. Nobody told me. I thought it was just a discussion, and I've already been painted as the devil, so I'll just answer questions if anybody has any. So that was great. But anyway, but if you want to know the Constitution, never go to law school, because you'll start off with the 14th Amendment, and a lot of people criticize Judge Posner last month when he said, don't waste your time reading the Constitution if you want to know constitutional law, and people decried it. Unfortunately, in the world of the Supreme Court and the federal courts, they're right. It doesn't bear any resemblance to the historic documents, which it should, of course. It's just shocking. But I'm going to try to focus on how we got here. And we've mentioned Marbury versus Madison. And let me go into that first, because I made a discovery this morning, literally at the last minute. Marbury versus Madison was the foundation. But does anybody remember, old enough, you don't have to admit that, but remember the Little Rock school case? Of course, if you look at the facts, there wasn't near as much violence as they claimed there was. A lot of that was being blown up in order to force Eisenhower to send the troops in. And he said later that was one of the biggest regrets he ever had after appointing Earl Warren to the court. By the way, later on, and I won't, since we're on tape, I won't say what he said, but he invited Warren to a party because they were friends. Of course, Warren stole the convention for him from Taft. But he actually told Warren what he thought of his ruling in the Brown versus Board of Education case. Very bluntly. So Eisenhower's kind of risen in my esteem a good bit after reading that. But anyway, that case was Aaron versus Cooper as it got to the Supreme Court. And it's amazing because they attempted, and this wasn't a mistake, they cited Marbury versus Madison, kind of. And what they did was they used it as the basis of their ruling. And in quotes, they quoted it. But they went on a little bit, and they stated, this decision, pointing to Marbury versus Madison, declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, and that principle has ever since been respected by this court and the country as the permanent and indispensable feature of our constitutional system. That happens not to be in quotes, and the reason it isn't in quotes is from Joseph Story's commentaries on the Constitution. That's the point they grabbed judicial supremacy at that point, and nobody ever challenged him on it. And they all got it, of course, from Joseph Story, who, can you imagine today a Supreme Court justice selling books on the side, his commentaries on the Constitution, you argue before Justice, from your own book, you say blah, blah, blah. I mean, it's kind of as bad as being a justice in a case where you would be the witness in. Just about ethically is just as bad, like Marbury versus Madison. So, they can get away with a lot. Like in Alabama, following Roy Moore, we have two probate judges, and one of which we had two charged a few weeks ago. We don't have any of those in here, do we? One was making sexually nasty, let's say, communications through Facebook to a woman, all done through his office, including photographs taken there of himself nude in the office. And he was busted by the newspaper. He was charged by the Judicial Inquiry Commission, but I knew they were getting ready to do something because they sped up the hearing day. And then we had a woman probate judge who'd been on the bench 28 years, who, of course, she presides over her own family's administration of the will. There was a big fight. Why not have somebody in the family handling all that? You don't want outsiders to hear all the dirty secrets. And she made the statement she had never heard of that being improper. So she retired, no sanction, she had plenty of time. And the other guy, he's just having counseling for a couple of months and warned people about social media. Well, I've used all those things for a long time and never sent any dirty pictures to anybody. So, and yet he'll be back on the bench in a couple of months, and we've got Roy Moore. Believe me, they will remove him. They can't wait. And if you analyze some of the people on the Judicial Inquiry Commission, because I've had a nice run-in with them. One was in business with Milton McGregor, the gambling kingpin of Alabama. Of course, gambling's illegal in Alabama. And a member of the Russian mafia to set up a lotto in Russia about 10 years ago. That's one of the members of JIC. So it's a real good group of people there. But anyway, getting back to Aaron versus Cooper, that's when the concept of judicial supremacy came in. Not the fact of judicial review, the fact that they are the be-all, end-all, the final word on what the Constitution says. And, of course, that's nowhere in the documents. It was nowhere contemplated by anybody. So let's swing back to the Judiciary Act, first one in 1787, right? Yeah. Long act, and of course we all know from Marbury versus Madison, Section 13, it was on dispute, but Section 25 is what gave the Supreme Court appellate review of, we all assume, the final decisions of state courts, usually called Supreme Courts, except New York, they have another strange, they're Supreme Courts, the municipal court or whatever. But that's what gives them the power to, number one, slow down all of our capital cases, so it takes 30 years to execute somebody. But I found I think it was a 1950s, it may have been 60s, law review about 6 o'clock this morning that referenced a series of newspaper articles from the 1840s by somebody we've never heard of who used a pseudonym that was the same pseudonym that Spencer Roane had used, so you're already starting off strange. And he analyzed the text of Section 25. Y'all stay with me because it's going to be really easy. And he's right. If you look at the text of 25, all the wording in there suits, and I've actually got the text here. All the wording in there applies to a civil case. It never says civil or criminal, but all the wording in there is classically applied to a civil case. And I've never read this theory before. I have never heard it before, but I tell you, I think he's onto something. I don't think there's any question about it. And I've never heard of anybody even bringing it up before. But I think so here. What does that mean? Well, what it means is it's half the battle that perhaps we have a chance in. Of course, we know the civil cases are the ones that have changed the course of the country. Recently the gay marriage case. Whether you think that's good or bad, the legislature should have voted on that, not the courts. That's the problem. And I love the people that supported that and were cheering. I'd always say, well, what do you think about Citizens United? That was a great decision too, don't you think? Or Bush versus Gore. That was a good one. They cringe when you talk about that. But everybody's all concerned about who Hillary will appoint. We shouldn't be concerned at all because it ought to be so irrelevant who she or anyone else appoints, because they shouldn't have that kind of power. Okay, here we are. All right, Section 25 of the Judiciary Act, and that's the first Judiciary Act, it uses these type words. It was written by a man named Charles Hammond, and he used the pseudonym Hampden, and uses these type of words in there, which just absolutely applies to a civil case. Let's see. Well, I thought I had it, but I want everybody to look at it. I'm going to have a stapler with you. Another thing to think about too, though, on criminal, every time that a right has been, one of the Bill of Rights has been incorporated against the states, it has hurt us. People think, oh, we've gained a right. No, it's really, when Miranda happened, when another one happened, it's really harmed us. When you had Madeleine Murray O'Hare took her case up there, there, and we had Hugo Black. You know, he actually formed his own through a series of 3 or 4 cases. He would cite his prior case as the basis of his new case. Every one of those harmed us. It did something to the country. And, you know, by doing that, it didn't expand any kind of freedoms we had. It harmed us. And come on. So I want you to hear some of these. Well, I'm coming back to that, but let me jump to that. Right. You had your Judiciary Act of 1875. Until 1875, the U.S. district courts did not have jurisdiction to hear cases and controversies involving the laws or Constitution of the United States. Now, that shocks most people today because state courts can't be trusted with the Constitution. You know, we're all racist, we're bigoted, we're stupid, you know, whatever the term. Federal courts only had jurisdiction of admiralty, diversity, etc. It was 1875 when they decided to change that. Another thing, and I think this is something you could cripple the Supreme Court with, they called it the Judge's Bill, but it's the Judiciary Act in 1825, unfortunately by Chief Justice Taft, who generally I kind of thought was a good guy. But instead of hearing appeals, it allowed them to hear writs of certiorari where they could pick out the cases they wanted to hear. And by picking out the cases, that allowed them to, that one looks interesting, so we can change the law in the Constitution. That one looks interesting. Their case flow was cut down at least by 15% of what it had been. Instead of being bombarded with, that's what they should be, bombarded so they don't have time to think about the mischief that they're causing. They have to just work and not be plotting, oh, how can we change the course of the country? They wouldn't have time to get into that. They would have to work and not be plotting these things. But, you know, there are people that are working all the time, working on these kind of things, when we're just doing our thing and going about our merry business. And I know there are. I've seen those type people. It's amazing. 24/7. It's kind of like a sex offender. They're working all the time. How can I get this kid and do whatever to him? We're thinking about how are we going to pay our taxes? What are we going to eat tonight? No. These kind of people are thinking all the time, how can we do this to ruin the country or move the country our way? Here we go. So it's not an overstatement to say that it happened this far back. Let's scroll it down. Okay, let's look at 25. It's a long one, and people don't want to read all this, but I'll have to read 25 when you look at it. If you don't know about Avalon, it's who one of the colleges maintains. It has all the historic documents on it, and it's not, they've digitalized it, so you don't have to read the old writing. It's a great resource. Okay. I've got them highlighted too. And it uses the word suit, highest court of law or equity. Those are civil terms, law and equity. They've merged those now, but we used to have two courts. Equity was divorces, it was restraining orders. None of those apply to criminal cases. Let's see, it says any suit involving a treaty or statute, any decision regarding a title, right, or privilege. Everything is dealing with a civil case. And Mr. Hammond there wrote it under a pseudonym in 1841. So I will let you all look at that and see what you think, because I was amazed when I hit a 50-something page law review, and it took a little while. It could have been 5 pages, but it's really interesting. But that's half the battle. What do we do about the other half? Because it has been serious. The Congress is really the problem. I did my part in standing up. Give you a little bit of background. When Judge Moore ran again for Chief Justice in 2012, I guess it was. I thought he was getting run over a little bit. We had all these former Republicans, rhinos, et cetera, were all endorsing Bob Vance, who was so far to the left, it just, that's fine, but just admit you are. And so I kind of concocted a scheme, and some of his people were just, hey, you don't need to do that. Well, he was getting beaten. So one morning my phone rings at 6, and you think, who's dead? Well, it was Judge Moore, and I'd never heard him that angry before. And he says, we got to do something about all this. And I said, are you still coming down to Mobile Thursday or whatever it was? And he said, yeah. And I said, why don't you let me handle it? So it was nice. It was clever. It was nice. And so I wrote a little bio of everybody that had endorsed Bob Vance. It kind of reminded everybody who they were. And like Bernie Harwood, nice guy. He was a justice and a judge from Tuscaloosa. And I said, and there's Justice Harwood. Everybody remembers him, second-generation member of the Supreme Court. He had a convicted felon driving him around when he was running for Supreme Court. Nobody seemed to complain about that. And I mean, it just went on and on. And then we have every one of them. I said, I think about every one Harwood was originally appointed by George Wallace. And I would say, and he got his political start from Governor George Wallace, and I would always back it. So we finished the press conference, and Judge Moore said, that just won it for us. And said, well, it's too early to tell. Well, he won later. And it was kind of amazing. About a year and a half later, I started getting targeted by JIC. And they are... We had a judge in Mobile that was trading gay sex for light sentences. That's the only way to put it. I mean, it was really bad. And the evidence was everywhere. And so a lawyer friend just kept bugging me, we got to do something, The authorities won't do anything. So we got a couple of prisoners, polygraphed them, had them polygraphed, no deception. And so we basically started building a case, and we took it to the FBI and U.S. Attorney, who were very interested. But as the election got closer, Obama's first election, they kind of got disinterested in the case. But we turned it all over to the Judicial Inquiry Commission, and they got interested in maybe charging him with transferring cases to his docket that he shouldn't be doing. Of course, that was transferring cases so he could make these deals on the side. It was unbelievable the extent they went to avoid getting into the issue. And there was more evidence there than I want to admit on tape, because it was really nasty. And wouldn't charge him. So it just depends on whether you're part of the club or not. And in Moore's case, there wasn't a single person in the state of Alabama who was bound by the Obergefell order. Remember, there's an order they issue, and then there's a decision or opinion. The opinion just says, this is the state of the law. The order says, you're commanded to do this, and if you don't, you're going to jail. There wasn't anybody in Alabama that was subject to the order in that case. The decision is great precedential value. I don't do with the Supreme Court's issued their decision or opinion. They can probably get a federal court in Alabama to enter an order against me pretty quick. But in the U.S. District Court case in Alabama, it was done so poorly that there was one probate judge to defend it. There wasn't a class. When I was one of the lawyers who represented Chief Justice Hooper, Judge Hooper then, and of course we had the election almost stolen from us, we had as defendant every probate judge, every circuit clerk, and every sheriff in the state. It cost us $15,000 to serve every one of those, but we had every one of them as defendant in the case, and that's the way it should have been. They just skipped all that to get to the end result that they wanted to. They were filing motions to hold Judge Moore and other probate judges in contempt in a case they weren't even parties to. I mean, it was the most unbelievable thing. And the paper was just cheering them on, all the media. And it was like, this is just basic due process you're violating. But if you said that, you were a nut. I mean, it was you're on the wrong side of history. That's the phrase. So I was kind of on the wrong side of history too, because I started getting harassed by JIC, and you cannot believe just the nitpicking harassment. It was just incredible. And so I finally said at some point, this is a good time to leave because I'm tired of all this. And I'm really kind of glad to get my constitutional rights back because they need to go. And, you know, this is the type thing, and I'm glad we have the cameras here. I had someone access my Facebook account with an IP address belonging to the court system assigned to one of those people on JIC and downloaded the complete history. I can't prove it was anybody with them. Nothing on there I'm ashamed of, but that's not quite kosher. I mean, it's like the ends justify the means. I've looked at every other states that have similar systems, and most of them have rules that you kind of know going in advance. For instance, most multi-judge courts that you go to, let's say a Supreme Court or a Public Service Commission, when you get the record, it'll say Judge so-and-so, you know, ask the question. You go before a JIC or a witness does, it'll just say JIC, even though there may be 10 people asking questions. It'll just say JIC. So you have no idea who asked the question, which violates the National Court Reporters standards. In my case, we actually filed an order, a motion that said, hey, we're asking you to use the standards that everybody else does. Denied. I mean, I think, why would you deny that unless you're trying to hide something? I mean, it's just, when I've seen the glimpse of what they've done, I think, you know, how many other people have they gone after like that? So that's neither here nor there. But, you know, because I kind of thought of doing some things. We're going to hear 10th Amendment here in a minute. I kind of thought of doing some things with our rules that you couldn't use any evidence, for instance, that had been obtained from many federal sources that have used the Patriot Act and some things like. And then I thought, you know, I've already got a big target on my back. That'd be really good if it was tracked down to me as the source. But there's a lot that can be done, but there's more that can be done by Congress. Congress tomorrow could repeal certain portions of these Judiciary Acts, and the federal courts would be they wouldn't be emasculated, they would be put in the position that they were supposed to be in. A simple vote of Congress. You know, we talk about all the time, we need 3 new amendments to the Constitution to do this, and of course we know that'll never happen, and we have plenty of people that introduce them, and surely they're doing it just for show because they know they're not going to pass. How about just simple acts of Congress and just repeal these things? You know, the Supreme Court's already ruled that you could abolish every federal court but the Supreme Court, and you could take the Supreme Court down, I think they said, to 3. So it'd be pretty easy if Congress exercised, I think, its responsibility to supervise the court system instead of just letting it go. And that's what they've done, just let it go. And they're certainly not guardians of the Constitution. When you see, let's say, the Korematsu order and Japanese relocation order in World War II, when Justice Frankfurter said, we're leaving this to the military authorities to decide what to do. It's their business, not ours. Yeah, he's a real guardian of the Constitution, isn't he? That's when I love the guy, Khizr Khan, shaking the Constitution, saying that Trump hadn't read it. I thought, well, have you read any of the Supreme Court's law about this? Because depending on who you are, they'll let you do anything, you know. In fact, in the Quran case, they Supreme Court let them execute the German U-boat saboteurs before the Supreme Court had even issued its order. So he may be reading the text, but he's not familiar with the case law on it. So since I got off on 25, any questions? Because I probably have over-prepared myself, but I could say the Moore case on any of this, if I had the votes, I could gut what they're doing. But, you know, it's just getting some of these people to do what's right and not perpetuate themselves in office. That's the problem. Anyway, thank you, and we'll have Q&A in a few minutes. Thank you, John, for reminding me.